Absolutely, I can dive deeper into Articles 3 and 9 of the Uniform Commercial Code, UCC, and the Credit Union Share Insurance Fund Parity Act, HR 3468. UCC Article 3, Negotiable Instruments. As you mentioned, Article 3 governs negotiable instruments, which are written promises or orders to pay money. These instruments, like checks, promissory notes, and drafts, are designed to be easily transferable, similar to cash. Key elements of negotiability. For an instrument to be considered negotiable under Article 3, it must meet specific requirements. Written. It must be in writing. Unconditional. The promise or order to pay cannot be subject to any conditions. Fixed amount. The amount of money to be paid must be a certain sum. Payable to order or bearer. It must be payable to a specific person, order, or to whoever possesses the instrument, bearer. Payable on demand or at a definite time. It must be payable either when demanded or on a specific date. Importance of holder in due course. A significant concept in Article 3 is the holder in due course, HDC. An HDC is someone who takes a negotiable instrument in good faith, for value, and without notice of any problems. HDCs receive special protection. They can generally enforce the instrument even if there were certain defenses that could have been raised against the original payee. Parties involved. Article 3 defines the roles of various parties involved in negotiable instruments. Drawer. The person who writes the check or issues the order to pay. Drawee. The bank or other party that is ordered to pay. Payee. The person who is to be paid. Endorser. Someone who signs the back of an instrument to transfer it to someone else. In essence, Article 3 facilitates the use of written instruments as a safe and convenient alternative to money in commercial transactions. UCC Article 9. Secured Transactions. Article 9 governs secured transactions, where a lender, the secured party, takes a security interest in the borrower's property, the collateral, to ensure loan repayment. Scope. Article 9 applies to a wide range of transactions where personal property or fixtures are used as collateral, including loans where businesses use inventory or equipment as collateral, sales of goods on credit where the seller retains a security interest. Key concepts. Security interest. A legal right granted by the borrower to the lender in the collateral. Attachment. The process by which a security interest becomes enforceable against the borrower. This typically requires a security agreement, value given by the lender, and the borrower having rights in the collateral. Perfection. The process by which the secured party makes its security interest effective against third parties, other creditors. The most common method of perfection is filing a financing statement with the appropriate public office. Priority. Article 9 establishes rules for determining which secured party has priority in the collateral if there are multiple creditors with security interests. Generally, the first to perfect has priority. Default and remedies. Article 9 outlines the remedies available to the secured party if the borrower defaults on the loan, such as repossession and sale of the collateral. In short, Article 9 provides a comprehensive framework for secured lending, balancing the rights of lenders and borrowers while promoting commercial certainty. How Articles 3 and 9 relate. While distinct, Articles 3 and 9 can sometimes intersect. For example, a promissory note, governed by Article 3, can be used as evidence of a debt that is secured by collateral under Article 9. Credit Union Share Insurance Fund Parity Act, HR 3468. This act aims to expand federal deposit insurance to include interest on lawyer trust accounts, IOLTAs, and similar escrow accounts held within credit unions. Parity. Parity, in the context of natural resource wealth and rights, refers to the principle of equal treatment, access, and benefits. It implies that everyone has an equal share, right, or claim to natural resources, revenues, or profits derived from them. Types of parity. Horizontal parity. Equal treatment among individuals or groups within the same category. Vertical parity. Equal treatment between different levels of government or administration. Fiscal parity. Equal distribution of revenues or benefits. IOLTA. Interest on lawyers' trust accounts. IOLTA is a method of raising funds for charitable purposes, primarily legal services for the underprivileged, by using the interest earned on specific lawyer trust accounts. Most states, the District of Columbia, and the U.S. Virgin Islands have Yes, there's more to discuss regarding the Credit Union Share Insurance Fund Parity Act and related concepts. Let's delve deeper. Key provisions of the Credit Union Share Insurance Fund Parity Act, H.R. 3468. Expansion of insurance coverage. The primary goal of this legislation is to extend federal deposit insurance coverage to IOLTAs and similar escrow accounts held within credit unions. Parity with banks. This act aims to create parity with banks, where similar types of accounts are already covered by the Federal Deposit Insurance Corporation, FDIC. Benefits for credit unions. This expansion would provide credit unions with a competitive advantage in attracting and retaining clients who may prefer the added security of federally insured accounts for their trust funds. Benefits for clients. Clients would have increased peace of mind knowing their funds held in IOLTAs within credit unions are federally insured, offering a similar level of protection as those held in bank accounts. Arguments in favor of the act. Enhanced security. Expanding insurance coverage would provide greater security for clients whose funds are held in IOLTAs within credit unions. Increased competition. This would create a more level playing field between credit unions and banks, allowing credit unions to compete more effectively for clients who require trust account services. Support for legal aid. IOLTAs play a crucial role in funding legal aid services for low-income individuals. Expanding insurance coverage could potentially increase the funds available for these vital services. Arguments against the act. Potential risk to the National Credit Union Share Insurance Fund. Some argue that expanding insurance coverage could increase the risk to the National Credit Union Share Insurance Fund. Regulatory burden. Implementing and overseeing this expanded coverage could potentially increase the regulatory burden on credit unions. Current status. The Credit Union Share Insurance Fund Parity Act was introduced in the 113th Congress but did not pass. Similar legislation may be introduced in future Congresses, and the debate around its merits and potential drawbacks is likely to continue. Disclaimer: this information is for general knowledge and informational purposes only and does not constitute legal or financial advice. Further research. You can find more information about the Credit Union Share Insurance Fund Parity Act by searching for the bill number, H.R. 3468, on the U.S. Congress website, linked to congress.gov. You can also research the positions of relevant organizations, such as the National Credit Union Administration, NCUA, and the American Bar Association, on this issue. I hope this more in-depth analysis provides a comprehensive understanding of the Credit Union Share Insurance Fund Parity Act.